What if I told you that some of the debts keeping you up at night may not be yours to pay at all, and that the law is actually on your side? For millions of Americans over 65, debt collectors' calls feel like a constant storm, bringing stress, fear, and a sinking feeling that you'll never get ahead. I've seen too many good people in retirement skip meals, delay medical care, or dip into savings because they believed they had no choice but to pay every bill that came their way. But here's the truth. There are certain debts you may be able to walk away from completely, without breaking any laws or putting yourself in danger. In this video, I'll reveal 6 common types of debt that seniors often think they're stuck with, and show you exactly how to protect yourself from paying money you may not owe. Before we get started, I want to hear from you. Where are you watching this video from, and what time of day is it for you right now? Let me know in the comments. Even an ordinary moment in your day matters to me, and if you find this content helpful, don't forget to hit that subscribe button so you never miss my next tip to protect your rights and your peace of mind. Credit card debt, past the statute of limitations. If you've ever gotten a phone call about a credit card bill from 10 or even 15 years ago, you know the jolt it sends through your chest. It feels like the past has suddenly reached out and grabbed your shoulder, shaking loose old memories and old fears. Maybe it was a rough time back then. A health scare, the loss of a spouse, or just a season when the interest piled up faster than you could keep up. You thought the account was long gone, maybe even forgotten. But now someone on the other end of the line is telling you that you owe thousands, and they speak with the kind of authority that makes your stomach turn. Here's what they rarely tell you. In every state, there is a legal clock that starts ticking the day you stop paying on a debt. It's called the statute of limitations. In some states, that clock runs for only 3 years, in others it might run for 6, and in a few it stretches longer. But once that clock hits 0, something important changes. The debt may still exist in theory, but they can no longer take you to court to force payment. The threat of a lawsuit, the thing they often use to scare you, is gone. The problem is, debt collectors know most people don't understand how this works. They know you hear the words, "you owe," and you think, "I have to pay." And they have a trick that can put all the power back in their hands, getting you to restart that clock. It doesn't take much. A small payment, even just $5, can do it. Sometimes all it takes is saying the wrong words like, "Yes, that's my account," or "I'll try to pay something." Suddenly, the statute of limitations resets, and the lawsuit threat comes alive again. This is why you have to be careful about what you say and what you do when that phone rings. If you're over 65, living on Social Security, a pension, or a fixed income, you don't need that added stress. You've already carried enough over the years. So here's my advice, as someone who has seen hundreds of seniors in this exact situation. First, never admit to the debt over the phone. You can be polite without giving them the words they're fishing for. Second, always ask for everything in writing. This is your right under federal law, and it forces them to show you exactly what they claim you owe and when the debt began. Third, check the dates. Look at your state's statute of limitations and compare it to the last time you made a payment. If the debt is outside that window, they cannot legally sue you for it. It's also worth remembering that you have the right to tell them to stop contacting you. You can send what's called a cease communication letter. Once they receive it, they can only contact you to say they won't be in touch anymore, or to let you know they're taking a specific action, like filing a lawsuit, which, if the statute has expired, they can't do. Having that letter on file puts you back in control of the conversation and takes away their power to call you day after day. I've had clients tell me that once they learned about the statute of limitations, it felt like a heavy door had opened. The constant buzzing of their phone didn't make their heart race anymore. They could sit down for dinner without bracing for bad news. That's the gift of knowing your rights. It doesn't erase the past, but it keeps it from stealing your peace in the present. So if a debt collector comes knocking with an ancient credit card bill, don't let panic take over. Pause. Breathe. Ask for the details in writing. Check the dates. If the time has run out, you can stand firm, knowing they can't drag you into court. You are not helpless here. In fact, the law may already be on your side. You just need to claim that protection. And that's not only about money, it's about guarding your well-being, your dignity, and your hard-earned peace of mind in these later years of life. Medical debt that has been charged off by the hospital. For many older Americans, the most expensive bill they will ever face doesn't come from a car or a house. It comes from the hospital. A surgery, a long hospital stay, or even a single trip to the emergency room can leave a person with thousands of dollars in charges. At first, you may think your insurance will take care of most of it, but weeks later, the envelopes start to arrive. There's one from the lab, one from the anesthesiologist, one from the physical therapist. Soon your dining room table is buried under papers, each one a reminder that your health came at a steep price. When you're living on a fixed income in retirement, those numbers can feel impossible. You might start to think there's no way out. But here's something few people ever tell you. Sometimes the hospital itself gives up on collecting that debt. This is called a charge-off. In accounting terms, it means the hospital has decided the debt is unlikely to be paid and writes it off as a loss for tax purposes. But just because they've charged it off doesn't mean the bill disappears. In many cases, the debt is sold to a collection agency for pennies on the dollar. And this is where things get tricky. That collection agency will call you as if you still owe the full amount. They may sound convincing, but often they can't provide the original paperwork that proves exactly what you owe and why. Without that documentation, their claim is weak. In fact, if the debt is several years old, it may already be past your state's statute of limitations, which means they can't legally sue you for it. Yet, they will still try to pressure you, hoping you don't know your rights. There's another layer to this, one that works in your favor but is rarely advertised. Many hospitals in the United States, especially nonprofit ones, are required by law to offer what's called charity care, or financial assistance to patients with low income or limited resources. If you're retired, living mostly on Social Security or a modest pension, you might qualify. But here's the problem. They don't go out of their way to tell you. In fact, I've met seniors who paid thousands they didn't have to, simply because no one mentioned this option. So what should you do if you get a call about old medical debt? First, don't panic. Take a breath and remember you have the right to ask for proof. Request a written validation of the debt. This forces the collector to send you documents showing the original creditor, the exact amount, and the date the debt began. Second, check the dates carefully. If it's been many years since the service, the debt might already be outside the statute of limitations, which gives you important legal protection. Third, find out if the hospital has charged off the debt and sold it. If they have, the collector bought it for far less than they are asking you to pay, which gives you leverage in any negotiation. Finally, look into whether you qualify for financial assistance or debt forgiveness based on your income. Even if the debt is recent, charity care programs can significantly reduce or eliminate what you owe. Every hospital has its own application process, but it usually involves providing proof of income and basic household information. I once spoke with a widowed woman in her 70s who was losing sleep over a $9,000 hospital bill. After we requested the documentation, we discovered the hospital had charged off the debt 2 years earlier and sold it to a collector. We also found that she would have qualified for full charity care if she had applied at the time of service. Armed with this information, she was able to stop the calls and keep her savings intact. She told me the relief she felt was like a weight lifting off her chest. She could finally focus on her health instead of her debt. Medical bills can feel deeply personal because they're tied to your most vulnerable moments. But knowing how charged off medical debt works puts you back in control. You are not powerless, and you do not have to accept every demand a collector makes. Ask for proof, check the dates, understand your rights, and explore assistance programs. Doing so can protect not only your finances, but also your peace of mind. And that's something no bill collector should ever take from you: debt. Solely in a deceased spouse's name. Losing a spouse is one of the most painful experiences anyone can face, and the weeks that follow are often filled with confusion, grief, and a heavy fog of unfinished tasks. You're trying to manage funeral arrangements, notify family, and figure out how to move forward. In the middle of all that, the phone rings. On the other end is a voice telling you your late husband or wife owed thousands on a credit card, and they're asking how you'd like to pay. For many seniors, this moment brings a fresh wave of panic. The caller might sound official, and their tone may suggest you have a moral duty to take care of this bill. They might even say things like, "Don't you want to honor your spouse's memory?" or hint that your own credit could be damaged. This is where understanding your rights becomes critical. Under U.S. law, if the debt was solely in your spouse's name, meaning you did not co-sign or jointly apply for it, you are not personally responsible for paying it. The creditor can only attempt to collect from your spouse's estate, which includes assets like savings accounts, property, or other belongings left behind. Your Social Security benefits, pension, or personal savings are not on the table for them to take, unless you legally agreed to that debt when it was created. Unfortunately, debt collectors know that in the aftermath of a loss, people are emotionally vulnerable. They use this time to apply pressure, hoping grief will make you say yes just to make the conversation end. It's not uncommon for them to call repeatedly, send letters with urgent language, or imply legal consequences that simply do not exist. Here's what you can do to protect yourself. First, always ask whether the debt was in both names or only your spouse's. If it was only in your spouse's name, calmly state, "This is not my debt. You must deal with the estate. Do not contact me again." Second, keep detailed records of every phone call or letter, including dates, names, and what was said. If the calls continue, you can file a complaint with the Consumer Financial Protection Bureau or your state's Attorney General. These agencies take harassment seriously, especially when it targets seniors. I remember speaking with a woman in her late 70s who had lost her husband after 52 years of marriage. She was barely sleeping, and her blood pressure had risen from the stress of daily calls about a credit card balance she never signed for. Once she understood her legal rights, she sent a short letter to the collector stating she was not responsible. The calls stopped within a week, and she told me it felt like someone had opened a window in a stuffy room. She could finally breathe again. It's important to remember that grief can make it hard to think clearly, and collectors know this. They might cloak their requests in polite words, but their goal is the same: to get you to pay money you do not owe. Knowing the law isn't just about protecting your bank account. It's about protecting your emotional well-being, your sense of stability, and the life you are trying to rebuild. If you find yourself in this situation, remind yourself that you are not doing anything wrong by standing your ground. You are following the law, respecting your own financial security, and preserving your health during a difficult time. No one has the right to use your grief as a tool to reach into your wallet. And when you respond with knowledge instead of fear, you take back control, one conversation at a time. Federal student loan debt after disability or death. It might surprise you how many Americans carry student loan debt well into their retirement years. Some took out Parent Plus loans to help their children attend college, believing it was an investment in their future. Others went back to school themselves later in life, hoping to learn new skills or start a second career. Now, in their 60s or 70s, they are living on Social Security or a modest pension, yet still making monthly payments on loans that seem to have no end. The weight of that obligation can feel especially heavy when health challenges or fixed income make every dollar count. What many don't realize is that federal student loans, including direct loans, plus loans, and consolidation loans, can be completely discharged under certain circumstances. The most important of these is the total and permanent disability, or TPD discharge. If you become totally and permanently disabled and are unable to work, you may not have to pay the remaining balance at all. The same protection applies if you took out a Parent Plus loan and the student for whom you borrowed passes away. And if you, the borrower, pass away, your family will not be responsible for the debt. The law is clear, but the information isn't always shared. Many seniors never hear about the TPD discharge, or they believe they won't qualify because they're not already receiving Social Security disability benefits. The truth is, there are 3 primary ways to prove eligibility. First, you can submit a certification from your physician stating you are unable to engage in substantial gainful activity due to a physical or mental impairment expected to last at least 5 years or result in death. Second, if you are a veteran, documentation from the Department of Veterans Affairs showing a service-connected disability at 100% or an unemployability rating will qualify you. Third, if you are already receiving Social Security disability insurance with a review period of 5 to 7 years, that record alone can be used. The key is that this process is not automatic. Loan servicers are not in the business of telling borrowers how to stop paying them. You have to take the first step. That means contacting your loan servicer directly and asking about the total and permanent disability discharge application. Once you have the right forms, gather your documentation carefully. Incomplete or unclear paperwork is one of the most common reasons applications are delayed or denied. I once worked with a retired teacher in her late 60s who had been making payments on her own graduate loans for over 20 years. After a serious health diagnosis, she had to stop working completely. She was living mostly on Social Security and a small pension, and every month that loan payment meant skipping something else, sometimes even medication. When she learned about the TPD discharge, she applied with her doctor's certification. Within a few months, her loans were gone. She told me the relief was as much emotional as financial. She finally felt she could breathe without the constant pressure of that bill. If you're in a similar situation, remember that this is not about avoiding responsibility. It's about using the protections that federal law has put in place for people who truly cannot work. Paying loans under those conditions doesn't make you honorable. It makes you vulnerable to financial harm you don't need to endure. So, take action. Call your servicer, ask about the TPD discharge, gather your medical documentation, VA records, or Social Security disability notice, and submit your application. Follow up until you have confirmation in writing that the loan is gone. The process might feel overwhelming at first, but the freedom it can bring is worth every step. In retirement, your energy and resources should go toward your health, your family, and your peace of mind, not toward a debt you no longer have the capacity to pay. Knowing this option exists could mean the difference between struggling each month and living with a little more comfort and dignity in the years ahead. Debt that was discharged in bankruptcy but is still being collected. Filing for bankruptcy is never an easy decision. For many seniors, it comes after years of struggling with bills that just won't go away, credit card balances that keep growing, personal loans with high interest, or medical bills from an illness or surgery. Chapter 7 or Chapter 13. Bankruptcy is meant to give you a fresh start. In simple terms, a discharge means those qualifying debts are legally erased. Once the court grants that discharge, you are no longer responsible for paying them, and creditors are no longer allowed to ask you for money. The types of debt that are typically discharged include credit cards, unsecured personal loans, medical bills, utility bills, and even overdue rent from a past lease. For many, this discharge is the first real breath of relief in years. It's a chance to move forward without the weight of old debt holding you down. But unfortunately, not every collector plays by the rules. Some will still try to collect on a debt they know has been discharged. They might call you, send letters, or even threaten legal action. This isn't just dishonest, it's illegal. Federal bankruptcy law has what's called a discharge injunction, which makes it clear that once a debt is discharged, collection attempts must stop. If a collector contacts you about a discharged debt, they are violating that injunction. Imagine this. You went through bankruptcy 5 years ago. It was difficult, but it gave you a clean slate. Then one day, you get a call from someone claiming you owe $4,000 on an old credit card. They speak confidently, hoping you've forgotten about your case or that you don't know your rights. Many seniors in this situation feel a spike of anxiety. They think, maybe I missed something. Maybe I still have to pay. That's exactly what the collector is counting on. Here's what you should do instead. First, pull out your bankruptcy paperwork and review the list of debts that were included in your filing. If the debt in question is there, it means it was discharged. Second, tell the collector, calmly and clearly, that the debt was discharged in bankruptcy and that contacting you about it is a violation of federal law. You don't need to explain your financial situation, and you don't need to apologize. Third, keep a record of the call or letter, including dates and the name of the person who contacted you. If the collector continues to contact you after you've told them to stop, you can file a complaint with the Consumer Financial Protection Bureau or your state's attorney general. In some cases, you may even have grounds to take legal action against them for violating the discharge injunction. Courts have awarded damages to people who were harassed in this way, especially when the collector ignored clear proof of a discharge. I once worked with a man in his early 70s who had filed for Chapter 7 bankruptcy after a heart surgery left him with more than $100,000 in medical debt. 3 years later, a debt buyer called, demanding payment on one of those old accounts. He was ready to agree to a payment plan until we reviewed his discharge papers together. The account was clearly listed. We sent the collector a single letter citing the discharge and the penalties for violating it. The calls stopped immediately. He told me later it was like having a door slammed shut on a storm, trying to blow back into his life. Bankruptcy is meant to be a turning point, a way to clear the slate so you can focus on living, not just surviving. Don't let anyone pull you back into the past by collecting on a debt that no longer exists in the eyes of the law. Your health, your peace of mind, and your financial stability are worth protecting. And when you know your rights, you can protect them with confidence. Small debts that cost more to collect than they're worth. Sometimes the debts that cause the most stress aren't the big ones. They're the tiny balances that keep popping up in your mailbox. Maybe it's an old cell phone bill under $200, a gym membership cancellation fee from years ago, or a forgotten medical copay. For debts under about $500, most companies won't spend the time and legal fees to take you to court. It's simply not worth the cost to them. If you're living on Social Security, a pension, or disability benefits, much of your income is protected by law from garnishment, even if a lawsuit did happen. That means these small debts rarely carry the legal threat collectors want you to believe. Still, they know a phone call or a strongly worded letter can cause anxiety, especially for older adults who value keeping their affairs in order. Here's how to handle it. Always ask for written proof of the debt. Check when it originated to see if it's past your state's statute of limitations. Most importantly, don't let a $74 bill steal your sleep or peace of mind. Your energy and health are far more valuable than a debt that may already be unenforceable. At the end of the day, what we've talked about here is really about more than money. It's about protecting your peace, your dignity, and the years you've worked so hard to enjoy. Knowing your rights can lift a huge weight off your shoulders, and every step you take toward understanding them is a step toward living with less worry and more confidence. These tips are shared for general awareness. If you're facing any health challenges, be sure to check with your doctor before trying anything new. I'd love to hear from you. Share in the comments what lesson or reassurance you're taking away from today's video, or simply write the word HOPE to let me know you're with me. If this message has been helpful, don't forget to hit subscribe, turn on the notification bell, and share this video with a friend or loved one who might need it. And as we wrap up, I hope you carry into the rest of your day a little more clarity, a little more calm, and the warm reminder that you are never alone on this journey.